Welcome to this episode of TaxSnax, which is on the case of Haworth and HMRC. And at the outset, I need to give a little bit of clarification because you may be familiar with the name of Geoffrey Haworth from previous decisions. It is the same taxpayer as in that previous litigation, and in fact the same trust and the same shares in the same company, but this is a different case to that which was previously brought. Mr. Haworth's previous case related to follower and accelerated payment notices, which required him to pay 8.7 million in capital gains tax when a trust disposed of shares in a company called Teleworks. And the notices were based on the Court of Appeal decision in Smallwood and were quashed by the Supreme Court in 2021. The follower notices were quashed on the basis that HMRC had not formed the opinion that there was no scope for a reasonable person to disagree that the earlier ruling denies the taxpayer that advantage and had overstated the conclusions in Smallwood. So that is the taxpayer that we're dealing with today. And we are dealing here, or rather the Court of Appeal was dealing with a double tax treaty between Mauritius and the United Kingdom dating back to 1981. And this case all turned on the meaning of place of effective management. The facts, briefly stated in case you haven't read the previous decisions in this case, were that Mr. Haworth established a family trust in 2000, and that held shares in a company called Teleware plc. Two further family trusts were established by other appellants, which held shares in a company called Workplace. The three trusts were established. The three trusts had their trustees resident in Jersey. There became a plan to merge Teleware and Workplace and to list the shares in the new company on the LSE. However, if that was done straight away, capital gains tax would have become due on gains accruing to the trusts as a consequence of that merger. Mr. Haworth's tax advisors, who were also the advisors of the Jersey trusts, went to counsel, who advised that the CGT could be avoided if the gains were realised at a time when the trust had Mauritian trustees and United Kingdom trustees were appointed within the same tax year as that disposal. And this is effectively what was carried out. The merger proceeded and the Mauritian trustee resigned in the same year in favour of UK resident trustees. And HMRC amended the tax return of Mr. Haworth and other appellants because they said a capital gain arising from the disposals of the shares in Telework was in fact chargeable. The appeals were dismissed by the FTT and by the upper tribunal, and this is what brought Mr. Haworth to the Court of Appeal for a second time. Now, the decision of the Court of Appeal sets out the relevant statutory framework in quite some detail. I'm not going to do that. It relied on the provision of then Section 2 of TCGA, setting out the territorial scope of capital gains tax, the provision in Section 69 that trustees of a settlement are treated as a single and continuing body of persons, and various other provisions in relation to the bringing into domestic law of treaties. So turning primarily now to the treaty in question, it's an OECD style treaty, and Article 13 provided at the time capital gains from the alienation of any property other than that mentioned in paragraphs 1, 2 and 3 of this article shall be taxable only in the contracting state of which the alienator is a resident. So the idea of the round the world scheme is that you make a disposal at a time when the alienator is resident in Mauritius. The residence provision was in Article 4, and it was the tiebreaker for non-individuals that was in question. And that was, where by reason of the provision of paragraph 1 of this article, a person other than an individual is a resident of both contracting states, then it shall be deemed to be a resident of the contracting state in which its place of effective management is situated. The court then went on to look at the provisions in relation to operation of ships or aircraft, and also the mutual agreement procedure, I think because these effectively gave contextual support to the ultimate decision of the court. They also set out some of the terms of the previous 1947 treaty between the United Kingdom and Mauritius, because that was something that could be taken into account. So that is the broad statutory scheme in which this round the world scheme was established, and the court described it as this. It aimed to ensure that the trusts were resident in Mauritius when the shares in Telework were disposed of, but resident in the UK later in the same tax year. On that basis, Section 86 of the TCGA could not apply. Section 86 being the section which imposes charges on settlors who retain an interest in a trust, broadly speaking. And it was hoped that the liability under Sections 2 and 77 would also be avoided as a result of Article 13 of the treaty, read with Article 4. The idea was that the trusts should be deemed to be resident in Mauritius under Article 4.3 on the footing that, during the relevant period, their poem was situated there. That would mean that in accordance with Article 13, capital gains arising from the alienation of shares in Teleworks were taxable only in Mauritius, as the contracting state of which the alienator is a residence. At that time, it may still not do, I don't know, Mauritius did not in fact charge tax on such gains. And so the gain from the Telework alienation would escape tax altogether were the round the world scheme to be successful. So I'm not going to go through what was decided by the FTT and upper tribunal. What I am going to do is look in some detail at what the Court of Appeal considered. This case has been argued on an ongoing basis a little bit on what is the distinction, if there is one, between central management and control, CMC, and POEM, place of effective management. So the first thing that the Court of Appeal did was to set out the central management and control test from De Beers Consolidated Mines Limited. This is Lord Loburn LC's explanation, and where he says that in applying the conception of residence to a company, we ought, I think, to proceed as nearly as we can upon the analogy of an individual. A company cannot eat or sleep, but it can keep house and do business. We ought therefore to see where it really keeps house and does business. An individual may be of foreign nationality and yet reside in the UK. So may a company. Otherwise, it might have its chief seat of management in its centre of trading in England under the protection of English law, and yet escape the appropriate taxation by the simple expedient of being registered abroad. He then cites some earlier decisions, the Calcutta Jute Mills and Sasena Sulphur Company decisions, and says that those cases involve the principle that a company resides for purposes of income tax, where its real business is carried on. Those decisions have been acted upon ever since. I regard that as the true rule, and the real business is carried on where the central management and control abides. And Lord Loburn LC went on to describe that as a pure question of fact, to be determined not according to the construction of this or that regulation or bylaw, but upon a scrutiny of the course of business and trading. And so the principles for CMC, which were set out by the Court of Appeal in Development Securities in 2020, were the following. A company resides for tax purposes where its real business is carried on, and that is where CMC actually abides. The principle applies in relation to subsidiaries, including special purpose vehicles. It is the actual place of management, not that in which it ought to be managed. A company may be resident in a jurisdiction other than that of its incorporation, not only where a constitutional organ exercises management and control elsewhere, but if the functions of the company's constitutional organs are usurped, in the sense that management and control is exercised independently of or without regard to its constitutional organs, or if an outsider dictates decisions as opposed to merely proposing, advising and influencing decisions. On the other hand, CMC of a subsidiary will not be taken to be in a jurisdiction other than that of its incorporation, just because it is following a tax planning scheme propounded by its parent. Nor need it matter that a company's board takes decisions without full information or even in breach of the director's duties. Events before or after the particular date in question may be relevant as casting light on the position on that date, and where a company is resident is essentially a question of fact. So the court then went on to cite Lord Justice Chadwick in Wood and Holden, and talk about the decision in Swedish Central Railway, where the Lord Chancellor came to the conclusion that you could have more than one place of CMC. It goes on to discuss some of the doubts about that proposition, and notes that sort of 35 years later in Swedish Central Rail, in Unit Construction Company Limited in Bullock, Viscount Simmons came to the conclusion that while the reasoning in Swedish Central Railway was not unimpeachable, it must now be regarded as clear law that an artificial person may, like a natural person, have more than one residence. And so that is quite an important background. You say, well, what does CMC have to do with poem? And the issue was the way in which the case has been argued at various points has looked at whether or not it is possible to have two places of effective management. The Court of Appeal then goes on helpfully to set out the relevant articles of the Vienna Treaty and the decisions of the Supreme Court in Anson, and the House of Lords in Fothergill and Monarch, also noting the decision in Commerzbank, and that sets the scene for the way in which this is interpreted. I'm not going to go into that. It's not actually that complicated, but essentially, when we're interpreting provisions based on an international agreement, we don't apply a usual English common law statutory approach. We have to do something a bit broader, and this drags in all sorts of things like the OECD Model Convention commentary. So, having set out the principles of interpretation that they're going to apply, the Court of Appeal then moves on to talk about the OECD commentary on Article 4.3, which is the residence tiebreaker for non-individuals. They set out the 1977 version of the commentary, an HMRC statement of practice, which talks about that commentary, and this is what HMRC said about the commentary. The commentary in Article 4, Paragraph 3 records the UK view that, in agreements which treat a company as resident in a state in which its business is managed and controlled, this expression means the effective management of the enterprise. More detailed consideration of the question in the light of the approach of continental legal systems and of community law to the question of company residence has led HMRC to revise this view. It is now considered that effective management may, in some cases, be found at a place different from the place of central management and control. This could happen, for example, where a company is run by executives based abroad, but the final directing power rests with non-executive directors who meet in the UK. In such circumstances, the company's place of effective management might well be abroad, but depending on the precise powers of the non-executive directors, it might be centrally managed and controlled and therefore resident in the UK. So the setting out of the commentary that accompanied the various changes to the model treaty, it continues right up to the version of the commentary that accompanied the 2008 model, where the commentary read, an entity may have more than one place of management, but it can have only one place of effective management at any one time. So it isn't until that bit first came in with the 2000 model, but this is an agreement from 1981. So that commentary didn't come into place that said, look, poem is a tie break until 2000. It's reflected in the 2008 commentary, and I believe it's still there in the current commentary from 2017, was it? So hopefully you can see that what's developing here is an argument as to whether or not CMC and poem are the same, whether or not at the time of the 1981 treaty you could have more than one place of effective management, and if you could, is that the relevant time at which we need to be looking, or do we need to be looking at whether or not the interpretation of the treaty changes, even though the treaty remains the same, as the commentary changes? So these are some of the points that the Court of Appeal had to look at. In their discussion, they start by saying the construction of place of effective management is not to be approached in the same way as if the words appeared in domestic legislation. No international tribunal exists to rule on the interpretation of the term, but it nevertheless has an autonomous meaning and falls to be construed in a manner which is international, not exclusively English. Now, one of the arguments for HMRC, one of the arguments for Mr. Haworth turned on the date at which, the commentary at the time at which the treaty was entered into. So in that respect, Mr. Haworth's counsel relied on the commentary to the 1977 model treaty and said that that indicated that during the period when the treaty was concluded, a place of effective management was effectively the same as a place of central management and control. That, it was argued, showed that at the time the treaty was concluded, effective management was located where a company's business was managed or controlled, so in the place of the CMC. The Court of Appeal rejected this, saying that the commentary from that time didn't help. They said the sentence in question forms part of a paragraph in which there is reference to preference criteria adopted in other contexts. Even if the sentence casts lights on the UK's understanding, this is not determinative. Other states cannot be taken to have subscribed to the United Kingdom's perception. They then said that another important point was that the concept of central management and control isn't well suited to perform the function of a place of effective management, because both the Model Convention and the Mauritius Treaty proceed on the basis that there can only be one place of effective management at any point in time. So if you can have two CMCs, that cannot be the test for poem, is sort of how the logic goes. And in particular, they said, by 2000, the commentary explained that while an entity may have more than one place of management, it can only have one place of effective management at any one time. These comments were not in existence when the treaty was entered into, but they reflect its terms. Poem was clearly intended to serve as a tiebreaker. A CMC, in contrast, does not necessarily produce a single answer. Although an entity normally has only one place of CMC, the authorities mentioned above show that that will not always be the case. That suggests that CMC is not well suited to fulfil the role of poem. And they then go on to quote some of what was said in Smallwood in that respect by the Special Commissioners. And in relation to that, it had been argued by Mr. Haworth that the approach of the Special Commissioners in Smallwood was problematic because they had resort to the 2000 commentary on the Model Convention, and that commentary post-dated the date of the treaty. And what the court said about this is that The Special Commissioners recognised that the relevance of commentaries adopted later than the treaty is more problematic because the parties could not have intended the new commentary to apply at the time of making the treaty. On the basis that ignoring them would mean shutting one's eyes to advances in international tax thinking, the Special Commissioners took the view that the safer option is to read the later commentary and then decide in the light of its content what weight should be given to it. So that was one point, but the court went on to say that Poem's role as a tiebreaker is evident from the terms of the treaty and the model convention themselves. Not only, therefore, is there no good reason to take other states to have accepted that CMC, as developed in our domestic case law, should govern the interpretation of Poem, but CMC is not designed to serve the same purpose as Poem and may not yield the single answer which Poem needs to supply. There was a further argument that if you did have two poems, that would just refer you back to the Mutual Procedure Agreement under Article 27 of the Mauritius Treaty, but the court simply dismissed that, saying there's no indication that that was envisaged to apply. The position is instead that it can be seen from the treaty that there was meant to be just one poem. So Mr. Haworth then argued on the grounds of Wood and Holden. He said Lord Justice Chadwick couldn't discern a significant difference between the two tests in that case. And what the court said about that was, look, those were obitive remarks, but they were also tied to the circumstances which the commissioners had to consider and the circumstances of that case, Wood and Holden. And more importantly, they say Lord Justice Chadwick didn't explain his reasoning, and they dismissed those comments of being not of assistance. And so they then came back to what place of effective management actually means. And they say that that requires the focus to be on effective management. So in Wensleydale Settlement Trustees, the Special Commissioners stressed the word effective, saying, I am not persuaded that realistically the place of effective management of the settlement was in the Republic of Ireland. I emphasise the adjective effective. In my opinion, it is not sufficient that some sort of management was carried on in the Republic of Ireland, such as operating a bank account in the name of the trustees. Effective implies realistic, positive management. And that was adopted by the Special Commissioners in Smallwood, this idea of realistic, positive management. It also struck the Court of Appeal in this case as apposite. And what they said was that if you approach matters on that basis, Poem can potentially be in a place other than that which, applying the Wood and Holden approach, CMC would be located. They said, Wood and Holden shows that where a company is incorporated in a country and its constitutional organs make their decisions there, its CMC will also be there unless the function of the company's constitutional organs are usurped. And the court went on to say, I do not think the position will necessarily be the same as regards Poem. Identifying the place of effective or realistic positive management allows matters to be looked at somewhere more broadly. And the judgment goes on to build on this, saying it can, as it appears to me, be legitimate to have regard to the circumstances in which trustees from a particular jurisdiction were appointed. The mere fact that in making decisions during the period they were in office, the trustees made proper decisions in accordance with their duties, without the decisions being dictated by outsiders or the functions being usurped, will not automatically mean that the Poem was in the relevant jurisdiction. If the trustees were appointed because it was appreciated that fulfilment of their responsibilities would cause them to take the decision, the Poem of the trust might not be in the jurisdiction from which the trustees come. So that is the proposition that the Court of Appeal used to find the place of effective management of the trust not in Mauritius. They go on to say this: the role of the trustees in Mauritius was effectively predetermined. In this case, as the FTT explained, the settlors, albeit with the advice and assistance of advisers, decided to adopt an overall single plan, and to that end exercised their power to appoint the Mauritius trustees for a limited period, in the confident expectation that they would implement the plan. While the Mauritius trustees genuinely made decisions and, in doing so, complied with their responsibilities, there was every reason to believe that they would decide as they in fact did and so further the overall plan. Even therefore, during the period in which the Mauritius trustees were in office, effective or realistic positive management was elsewhere. The decisions which the Mauritius trustees made had been preordained, and the Mauritius trustees were doing no more than the settlor had, with good reason, foreseen. The Mauritius trustees were, without impropriety, playing their parts in a script which had been written by others. And the decision goes on to note that that understanding of poem is consistent with that in the Court of Appeal judgment in Smallwood. Then sets out some of what was said in Smallwood, which I'm not going to go into any detail on. There is a bit of a criticism of some of what Lord Justice Hughes said in that case. But what the decision says was clear in Lord Justice Hughes' decision in Smallwood was that he considered that the poem should not be determined by reference only to the circumstances at the moment of disposal or on Wood and Holden principles. There was a broader view taken, and a poem could be found in the UK on the basis that there was a scheme of management of the trust which went above and beyond the day-to-day management exercised by the trustees for the time being, and the control of it was located in the United Kingdom. So that led to the conclusion that the Court of Appeal would not be persuaded that the First Tier Tribunal approached matters on an erroneous basis, and they said in particular the FTT was right not to determine the poem of the trust by reference to the principles seen in Wood and Holden, and the appeal was dismissed. Lord Justice Arnold and Sir Andrew McFarlane agreed with the decision in whole. They didn't give separate decisions to the one given by Lord Justice Newey. So that's Haworth. Now, given Mr. Haworth's history, one can imagine that this is probably going to be appealed to the Supreme Court. Whether or not it will make it, I don't know. It's an interesting point. I'm not sure that there is anything particularly novel or of great importance in this case. The principles that are being applied are fairly well established. It's well reasoned, but let's see. It's a very thorough judgment, presumably because there was, well, not only because Lord Justice Newey is very thorough, but also because there's maybe one eye to any possible appeal to the Supreme Court. So again, this is very much a watch this space case because it seems like it might be appealed. Whether or not permission will be given, I think, is a different matter. Thank you for watching. Do watch some more of our TaxSnax, including the other ones in this series, which talk about interesting cases that we've had judgments on over the summer. Thank you.